大家好，我是曾博荣律师，我也是阿凯迪亚的副市长。谢谢你来我的频道，律师怎么说？我发觉说，华人经常来美国的时候，有很多的问题，其实他们都一直在脑海里面，不知道怎么答复。所以我希望说，我们这个频道可以帮助我们的华人。谢谢。
Let's talk about the last portion, and that is hire to fire. Let's talk about the fire portion. Now, the fire portion really is an issue, although I use hire to fire, it's really any type of termination of the employment relationship. That could be that the employee quits, that could be that the employee resigns, that could be that the employee just walks out, that could be where the employee is actually terminated. Now, here's the question that I have for an employer when you want to terminate an employee. California is an at-will state, and what does that mean? An employer can terminate an employee for any reason as long as it's not illegal. So whenever you hear the word at-will and you're kind of confused, now you know. So I'll give you an example. Let's just say I'm wearing one of my favorite clients, right? Sriracha it's a great company, and I love them. I'm wearing the Sriracha socks. I don't know if you can be able to see. They have really good socks over at Sriracha. So it's red, it's blue, and it's green. It's got bottles stretched across my socks, so my feet are big. Let's say the employer comes up to me and says, I don't like your socks. I don't like Sriracha. I don't like red. As stupid as that sounds, that's totally okay in California. Totally okay in California. What's not okay is to say, you know what, this white handkerchief, only Asian people wear white handkerchiefs, or only gay people wear white handkerchiefs, or only this, or only that. Therefore, I'm going to terminate you. That's obviously illegal. That's obviously going to be an illegal termination. But in terms of a termination, we have to revisit the issue. Is if there is a dispute, are you going before a bunch of employers that understand at will, or are you going to be going in front of employees that really don't understand what at will means? So when an employer comes to me and they say, I would like to terminate somebody, I don't ask them, are they at will or not at will? Do they have a contract or not? Are they independent contractor or not? I always ask them the question that every juror is going to ask, why? Why are you going to terminate this employee? Tell me why. And if the employer has a reason, I always ask, do you have documentation to substantiate that termination? So I'll give you an example. Many employers, rightfully so, don't like employees being late. Why? Because employees that are late, it's kind of like a cancer. Don't mean to use a very extreme word, but attorneys say that all the time. Is it spreads. It spreads all over if you don't take care of it. Because one person says, well, if that person can do it, why can't I do it? All right, why is it okay for Sarah to be late, but Tim can't be late? Is that discrimination? Is that a problem? So Tim's going to be late. So now Sarah and Tim is late. And next thing you know, everybody's late. So employers are frequently struggling with people being late. Well, here's the question I have. If Sarah has been repeatedly late, can you be able to document for me that you have either told her, or you can be able to document that it's occurring all the time? And can you be able to document that she's the most extreme case? Because what ends up happening is that an employer provides a justification, but when the employer is sued, the justification falls. So I'll give you an example. I used an example of Sarah and Tim. Sarah's always late, and Sarah is fired, and the reason is because she's late. And then we ask, or the plaintiff, Sarah, asks for all of the time records of the employees. And guess what? Sarah is not the most late. In fact, on a scale of 1 to 10, Sarah's like a 5. Tim's been copying her, but Tim's really late every day. Sarah's late twice a week, but your rationale for firing Sarah is now extremely weak because it looks like you're discriminating against Sarah. You're retaliating against Sarah because of her protected class. In California, there are so many protections. We have more protections than any other state. We have protections on our hair. We have protections on our gender. We have protections on our sexual orientation. Many states don't have all the protections that we have. And so that's the reason why I always ask the employer, why? The first question is, why? The second issue is, do you have documentation to substantiate your why? Now, the employer will typically tell me, well, I've been struggling for 6 months, a year, 2 years. I always say to the employer, welcome to the club. I've struggled too. I have had poor employees too. Even at a law firm, I've had employees that I have not been happy with either. But you know what? An employer typically is holding it within their tummy, and it just blows out sometimes 6 months, a year and a half later. But unfortunately, during the time when you have had problems with this employee, you have not documented it. And I basically tell the employer, if the employee really is this bad, if they're really that bad, then they're going to continue to be bad, and you can start documenting it and give it about 6 months and let's revisit the issue. If the employer says, you know what, I really can't, is there any other way you can be able to do, and this is not a legal document, but it's really what attorneys have done. It's called a performance improvement plan. And many companies out there call it essentially a PIP, a PIP. And so on a PIP, what you do is you identify the issues, you write down all the problems, you provide any documentation that you have or really don't have, and you identify to the employees the problems that are there to allow the employee to improve. Let's just use the example of Sarah again. Let's just say Sarah is late. She's not a 10 every day. She's not a 1, meaning that she's on time every single day. She's late 2 to 3 times a week. And she's been like that for, let's say, 6 months or a year. Your performance improvement plan would be able to say, Sarah, here's a problem that I have with you. You're late every single day, or you're late 2 to 3 times a week, and it's causing a lot of friction and problems at work. I need you to be able to improve on this situation, or there's going to be adverse consequences to your employment relationship. Let's just say Sarah does a 180 and she totally changes. Aren't you happy as an employer? Aren't you happy? But let's just say that Sarah now says, you know what? Screw you. I don't care. I'm going to be late even more. Well, in a situation like that, what do you have? You have the documentation that's necessary to be able to justify the why. So once there is a dispute, you could be able to present that objective documentation over to your attorney as well as plaintiff's counsel so that they can be able to litigate the case properly. Now, today I've spoken on both sides. I've spoken both on plaintiff side and defense side. And I think actually that's what makes our firm really good. We do, obviously, a lot of good areas of law. I personally do business, real estate, and labor. Those are my 3 best areas. We have other areas of law that other attorneys handle. But my last recommendation is this. If you are an employee, because lack of documentation also exists on employee side as well. Typically, employees aren't looking to sue. They're just looking for a change or an investigation or some type of response. Write it down, send it to your employer. There is nothing wrong with doing that. I know it's scary. It's scary for the employee. It's scary, just as scary for the employer. But you know what? If you give an opportunity to your employer to make that change, I think that 80% of employers that are out there, 1, probably didn't realize it was a problem, and 2, even for purposes of trying to avoid litigation, want to be able to resolve the matter with you. Because ultimately, we're not looking in California for more employment cases. I mean, yes, a law firm is run on cases that come in, but my hope overall is that in our short life, 36,000 days, I probably have 10,000 days left, not that many days left, that we live in peace, because ultimately both sides are working hard, particularly during COVID. COVID has been so difficult. It's caused a lot of tension. And people aren't interacting with each other. Everybody has become so explosive, whether you're employer or employee. If you're an employee, you have a problem at work, the best thing for you to do, in my opinion, is to write that letter. Write down your problems. Allow the employer to have corrective action. Allow the employer to even disagree with you, because at least you know you're being heard. From the employer standpoint, if you do receive something from an employee, don't ignore it. Even if you think the employee is ridiculous, right? I hear that all the time. Employee's ridiculous. How could they feel that way? Right? We take them out to dinner. We treat them so well. We're not violating the law. Well, you know what? If an employee sends you a concern and you try your best to resolve it, please do it in writing. Please involve the employee, because I think ultimately, just like a marriage, I'm going to go back to marriage, is that employment disputes are no different, and in some ways even worse than divorces. And to avoid a nasty divorce, in my opinion, the best thing to do is to communicate, to be able to be open, to be able to improve, and hopefully be able to have that business that you've always wanted, to create a business that you want to work and where your employees want to work. Thank you very much for your time.
今天这是我们本系的内容，如果你喜欢的话，给我一个点赞、留言跟订阅，谢谢。